Hi guys, this is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. We've had a lot of issues from the community wondering what's going to happen with the legal immigration side of Obama's executive action. And we've got a lot of traffic on this on my Twitter account, which is open right now in front of you. Uh, People were asking, well, with the ruling from the Texas court against Obama's immigration action, what is going to happen to the legal actions that were planned, both in the executive action and then the H-4 EAD regulations. To answer your questions, first, let me summarily say the legal immigration action is not affected, neither the regulations nor what President Obama had contemplated he would be doing, including filing of adjustment of status with the I-140 without waiting for priority date to be current. So those things are still alive. When are those sides of President's immigration action going to be implemented? That's very difficult to say. The reason is the president's actions or his contemplated reform can be implemented in two ways. One is through regulations. As you have seen, the H-4 EAD regulation, over 1 year, it's just been hanging around, nothing has happened. Although I'll come to that, thanks to Prakriti Sharma, one of the members of our community. She sent me a link and said, Rajiv, can you check this? And when I checked it, I think there might be some movement. It's hard to say on the H-4 EAD side. But getting back to how can this be implemented, one is through regulations, which can take a long time, and the other one is through memos. So if USCIS were to issue a memo saying from now on you can file your 485 with your I-140 without waiting for the priority date to be current, it will be implemented immediately. So we don't know when, we don't know how, but the possibility exists. One bad thing about the Texas order from the court is that there was one indication. I haven't read the whole thing. It's 123 pages. I have to make a living. I can't spend a lot of time doing, to me, unnecessary reading because we don't know what's going to happen eventually. It still might go in appeal and one in appeal. But one of the observations made by Judge was that Obama government cannot make some of these reforms without going through formal regulation process. So that might make the government a little bit leery about putting out just memos to change things. When it will be implemented, we don't know. It is alive. H-4 EAD movement, and I will get into this more detail. I wanted to give you an executive summary in the beginning so you don't have to listen to my whole spiel if you don't want to. If you want to understand the process better, I will talk. And we will talk further if you guys want to log into our community conference calls. Today we have one at 12:30. You can 12:30 Eastern Standard Time. And if you go to our homepage, right here is a link on the tab on how to log into the community calls and what is the process. So 12:30 you can log in. We can talk further about this. The part about H-4 EAD. So what Prakriti did was she sent me a link right here. This link said, Rajiv, can you take a look at it? And when I go to this link, it brings me to the Office of Management and Budget, which is the office that approves certain parts of the regulatory process, including new forms. And when you click on the form right here, I don't want to save this. I want to open it. Give me 1 second. Oh, this sucks. Okay, I might have to edit some of this out. But here is the form. The form talks about, if you look right here, it talks about the eligibility for an H-1 process. Let me expand this form a little bit. Let me see how to do that. Okay, this is not easy. So if you look at this part, the question number 18, it talks about if you entered the eligibility category in question 16 above, the category C26, enter the receipt number of your H-1B principal spouse. So it looks like they are making a change to Form I-765, which is the employment authorization document, um, to accommodate for H-4 EAD. That's a good sign. My first instinct was to say, Prakriti, this is really not much because this is just a proposed change, which they are going to, it's just an old version of the form, dated August 6, 2014. But then I also saw the watermark on the draft, which says this was Feb 13th, 2015. So there may be actually some movement. It is difficult for me to say at this point of time. But Prakriti, thank you for this. I'm always very pleased to see how our people are keeping track of all these things, and better than us sometimes, because we have so many things going on. But yeah, please keep it coming. Let me know if you want me to comment about something. So H-4 EAD may be moving. I don't know how fast, I don't know when, but this could be a positive sign. Although this could just be a part of the regulatory process, which is separate from the actual finalization of the regulations, which is what we are looking for. Now, let me talk to you a little bit about, is the legal immigration part also going to get challenged? And I think there is a challenge in the DC courts. I don't remember, I seem to have read it in passing, but there was no preliminary injunction being asked for. If I remember correctly, the Texas ruling is a preliminary injunction. What's a preliminary injunction? Okay, so if I sue the government, typically, if I'm asking them to say, okay, this part of the immigration action is wrong, the case goes on 6 months, 1 year, 2 years. At the end of the case, the judge decides whether something is wrong or right. In the meantime, whatever the government has decided goes on. So the action goes on until it is held to be incorrect or wrong. In certain cases, when there are certain requirements, and if you read the Texas decision, it tells you what those requirements are. Typically, before even the action is implemented, court says, wait, we need to decide this issue before you can implement this. That's called a preliminary injunction. Okay. In the DC action against legal immigration and H-4 EAD, there was no preliminary injunction. So it could be a few months or years or a couple of years before that action is decided. I don't even remember if the court said the people who were suing actually had standing to sue. I think the court did. I haven't been keeping track of this lawsuit. Frankly, I'm not taking it very seriously because I don't think there's much in it. Remember, one of the requirements from the Texas court was that no rule making or regulation making was done. In this case, in H-4 EAD case, that was actually done. Folks, this is all I had to say for today. Join me, if you like, in the community conference call at 12:30 Eastern Standard Time today. I will discuss the H-4 EAD at the end of the conference. So you may want to log in a little bit late, not to be bored by all the discussion. Let me just try to remember if there's anything else. Let me go over the discussion here. Okay. So, yeah, basically everybody's asking me the same question. I think we have covered it all. Folks, hope to see you in the conference today. Bye-bye.
Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.